Welcome everyone to our webinar, Don't Sign That Contract, What Businesses Should Review Before Signing. My name is Kathryn Wallace and my co-host is Georgia Mackay. Before we begin, a couple of quick housekeeping items. You'll receive the recording and slides in your email at the end of the webinar. Please submit your questions in the Q&A box and we will answer them at the end of the webinar, and we would be grateful if you could please complete the feedback survey after the webinar. For the next 48 hours, you are eligible for a free consultation with LegalVision to discuss how we can help your business. Please provide your contact details in the survey at the end of this webinar, and one of our team will reach out to you. Now we have a short poll question, which we would be grateful if you could please answer, and we'll give you a couple of moments to do that. Awesome. So today we will be discussing the importance of contract terms, indemnities, exclusions of liability, IP ownership, commercial obligations, unfair contract terms, insurance, and then we will finish with a question and answer session. And now Georgia will speak about the importance of getting your contract terms right.
So we'll start with why it is important to get your contract terms right. Reviewing and amending a contract before signing is a really important protection for your business. Often it's tempting to sign an agreement to get the engagement started and then consider the implications of its terms down the track. However, reviewing and amending an agreement before signing is one of the best things you can do to protect your business. It's often easier negotiating terms at the outset while the parties have a good relationship, rather than scrambling to figure out the terms when there has been a breakdown between the parties. Carefully considering a contract before you sign it can be beneficial, as it ensures that both parties have a clear understanding of the terms and conditions, preventing any misunderstandings and disputes. It enables you to verify that the contract aligns with the objectives and expectations of both parties. It clarifies the purpose of the agreement. It also enables you to evaluate the scalability and flexibility of the contract to accommodate potential changes in business needs or unforeseen circumstances, again, minimizing the need for frequent renegotiation. It also provides an opportunity to confirm that the contract complies with relevant laws and regulations to avoid complications or invalidation down the track. It also gives you an opportunity to confirm that timeframes and deadlines are realistic and achievable, preventing unnecessary stress and any issues with potential performance. And ultimately, it helps limit the risk of disputes based on the terms of the agreement. So this webinar will set out some of the key clauses that should be considered before you sign any agreement. Considering if you'll accept or reject a term of a contract involves a balance of commercial considerations and the risk that you and your business are willing to accept. It will also require input from your lawyers, who are happy to help you navigate reviewing any contract.
So what is an indemnity? Your contracts may include an indemnity, and these are relatively common and usually one of the more heavily negotiated aspects of a contract. This type of clause will set out how one party agrees to compensate the other party for specific losses or liabilities that may arise in the course of performing a contract. The purpose of indemnity clauses in contracts is to allocate risks between the parties and usually to protect one party from potential financial harm. So why are they important? Indemnities can help with risk management, protection from loss, avoid ambiguity and potential disputes by clearly defining the scope and limits of the indemnification, and they can add certainty for parties as to the liability they will be taking on or the risk they might be taking on in the contract. They are a key negotiation tool, particularly when there's a high value contract. Indemnity clauses are often included to outline the extent to which one party will compensate the other for losses, damages, liabilities, or expenses that may arise due to specified events or circumstances while performing the agreement. So what are some common indemnities? An indemnity can take various forms, and common examples we often see are indemnification for breach of contract, indemnification for third-party claims, including breaches of privacy, regulations, or infringement of third-party intellectual property rights, or product liability indemnification to cover harm that may flow from a defective product. So the last two being indemnification for infringement of intellectual property rights or product liability harm we would often see in, say, for example, a distribution arrangement, where one party sells its goods to the other to then distribute on its behalf. So the party whose goods are being sold to end consumers would normally indemnify the distributor against third-party intellectual property infringement claims, as well as defective products. So what is the risk of accepting an indemnity? When indemnities are appropriate and reasonable, they shield both parties from potential financial vulnerabilities. However, sometimes they are inserted as a way for another party to shirk their responsibilities or to overextend their rights. And when this is the case, they can pose a significant risk to your business, and in this situation, they should be removed or amended. An indemnity is considered more high risk because it can potentially expose a party to unlimited financial liability for specific losses, making them responsible for a predetermined set of circumstances regardless of fault or negligence. If an indemnity can't be removed, it can be amended to make an agreement less prejudicial to you. Some ways of doing this are to include specific exclusions to narrow the scope of the indemnity. Introducing specific exceptions within an indemnity clause can prevent the other side from overreaching and can ensure there is a more nuanced allocation of responsibility. Another way to amend an indemnity clause to reduce the risk is to set a maximum financial cap, which establishes that if one party is going to pay for the loss under an agreement, it will only be up to a certain amount and will not go beyond that amount. We often make this limitation the total amount of fees paid under the agreement, or if the agreement is long and ongoing or very high value, the total fees paid over the preceding 12-month period prior to the claim under the indemnity arising. We can also integrate a clause that states that where a loss arises under the agreement, it will be reduced proportionately based on the contributions of the other party, so that it is not the case that either party is taking full responsibility for something both parties have contributed to. In line with this, we would also include a mitigation clause, which requires the party who wants to rely on the indemnity to mitigate their losses as far as reasonably possible. Georgia will now speak to exclusions of liability.
So we'll start with looking at what an exclusion of liability is. So an exclusion of liability is a contractual provision strategically designed to shape and restrict a party's accountability for specific types of losses, damages, or risks within the framework of an agreement. These clauses are inserted as an attempt to limit or exclude a party's liability for certain types of losses that may pop up in the course of an agreement. In other words, it's an attempt to define the scope of responsibility and limit the extent to which one party can be held legally accountable for specific outcomes. So some common exclusions of liability. Some common types of exclusions include consequential loss. So this is a type of loss that will be defined specifically in the agreement, but will generally cover indirect or special loss. This could be loss of profits, business interruption, or reputational damages. Another type of exclusion could be loss of data. This is often included as a type of consequential loss. This exclusion will depend on the types of services you offer or are receiving, and this is pretty common for IT contracts where data is being handled between the parties. Another one would be third-party inputs. This typically applies where the services of a third party operate alongside the services you are providing or receiving under the agreement. The providing party will generally not want to accept liability for these third-party elements. Again, this is common for IT contracts.
So turning to intellectual property, this is often another very key aspect of a commercial contract. So what is intellectual property? Intellectual property can include patents for inventions, trademarks for distinctive symbols or names, copyrights for original works of authorship, and trade secrets for confidential business information. When reviewing a commercial contract, it is important that you consider what intellectual property is relevant to your agreement. So you should define and clarify who will own the intellectual property created, used, or modified under the agreement. Clearly outline the rights and restrictions related to each party's ownership. If either party is sharing existing intellectual property, such as proprietary information, software, or methodologies, ensure that the agreement explicitly states that the sharing party retains ownership rights. Clearly specify the rights granted to each party for using the intellectual property, and if there are limitations or specific purposes for which the intellectual property can be used, these should be explicitly stated. If the agreement involves the licensing of intellectual property, you should define the scope of the license, including any geographic limitations, and you should also be explicit about any exclusivity arrangements. It is important that you identify and address any third-party intellectual property that may be incorporated into the services or deliverables. You should clearly outline the responsibilities regarding third-party intellectual property compliance. Another key aspect of intellectual property in an agreement, particularly where parties are collaborating or creating something together, is who owns the new intellectual property developed or created as a result. It is important that it is clear whether one party owns it and then licenses it to the other, or it is jointly owned. However, jointly owned has its own issues and can be a very messy way to own intellectual property, so we would normally advise against that. It is important you ensure that the agreement and the use of intellectual property comply with relevant laws and regulations, both domestically and internationally.
So the commercial obligations are another key point to review, as these deal with the purpose or the why of the agreement that you're entering into. So the first thing you want to look at is what are the services being offered or received. When setting out the services you are providing or receiving, we recommend being as specific as possible about the scope of services, including setting out any deliverables you or the other party is providing. This ensures that both parties clearly understand what the services entail and can help avoid disputes in the future. Setting out the specifics of the services can also limit the risk of scope creep, that is, where a client is requesting continuously additional services that have not been clearly included or excluded in a contract. Depending on the type of contract, you may also want to insert acceptance testing clauses to assess the services and deliverables. Again, this is another common inclusion that we see in IT agreements. The next thing to consider would be what information is required to provide the services. So if you are the one that is providing them, you will want to set out the specific information you may need from the other party in order to complete the services. So this might include specific instructions about the services, designs, or even intellectual property. If you are the service provider, these details need to be included in the agreement so that if your customer does not provide the information or that information that they have provided is inaccurate, you're not responsible for any delays to providing the services or errors as a result of the information provided. Next to consider is what warranties are being offered. You should be considering any warranties being offered in any agreement before signing. You may require specific warranties from the other party about the standard of services. And if you're providing the services, this could be that your client will provide you with accurate and up-to-date information, or that they have authority to enter into the agreement. If you are receiving the services, you may require a warranty that the services being provided are being provided with due care and skill in accordance with professional standards, or that the services comply with any specific laws relating to your industry or the purpose of the agreement. So some examples of common warranties would be service performance warranty. So that's warranting that they're providing the services. Non-infringement warranty, that would be to ensure that they're not infringing on any other party's IP. Fitness for purpose warranty. So this is to ensure that the services that they are providing to you are actually fit for the purpose that you want them for. The next thing to consider would be the payment structure. So what are the fees for the services? Who's getting paid what? This will also need to set out how often invoices will be issued and when they will need to be paid. You'll also want to note if it's, a one-off payment, if it's an hourly rate, how that's structured. Another important point is if there's going to be any interest charges or debt recovery costs if the fees are unpaid. So the price of services is a really key commercial term of any service agreement. And it's also important to note that non-payment of fees is often a breach of a contract.
Thanks, Georgia. So continuing with commercial obligations, what is the scope of the agreement and is there a mechanism for making changes? So if there are aspects of the agreement that aren't known at the time of signing or that may require additional agreement down the track, make sure there is a clear provision to allow for this. Note that to be enforceable, this provision needs to be sufficiently detailed and certain, ideally with reference to an objective mechanism or process for reaching agreement, as generally agreements to agree on something at a future date are not enforceable if they lack certainty. Some agreements have a mechanism for multiple orders or requests, and the details of the arrangement might change from request to request. If this is the case, the agreement must be structured clearly enough to allow for this. Situations where we would normally see this would be in the form of, say, for example, a master services agreement under which the parties agree discrete statements of work. Most agreements will only permit changes by written agreement in writing or a formal deed of variation. There are occasions for shorter-term contracts, for example, month-to-month arrangements or sometimes software contracts, that will allow one party to update or amend their terms or fees following a brief notice period, for example, 30 days. These variation clauses can have a significant impact on how your contract will operate after it is signed, so it is important to get it right. Other key obligations are term and termination. How long is the agreement for? Can it be terminated? What happens if you or the other party want to terminate early? And can it be renewed? When evaluating the term and termination provisions within an agreement, it is essential to ascertain whether a predetermined time frame governs the arrangement. It's also important to know whether there are provisions for automatic renewal or extension, and identify any events that might trigger a modification in the term. Equally crucial is an understanding of the circumstances granting either party the right to terminate the agreement. If you lack the right to terminate at your discretion, it becomes imperative to determine if this condition is a potential deal breaker before committing to the full term of the agreement.
So next we'll look at unfair contract terms. So what is an unfair contract term? Unfair contract terms typically arise in standard form contracts. This is where one party has a greater bargaining power than the other. If a contract contains unfair contract terms, it may be unenforceable or at risk of attracting regulatory action from the Commerce Commission. The Fair Trading Act 1986, as amended in 2015 and again in 2022, introduced provisions to protect consumers and small businesses from unfair contract terms. So there are some key characteristics of an unfair contract term. The first would be significant imbalance. So unfair terms are those that create a significant imbalance between the parties' rights and obligations to the detriment of the consumer. Next is not reasonably necessary. So a term is considered unfair if it's not reasonably necessary to protect the legitimate interests of the party who would benefit from them. Terms that go beyond what is reasonably necessary to protect a party's interests may be deemed unfair. And also if it causes detriment, so unfair terms have the potential to cause detriment to a consumer. So detriment could manifest in financial losses, restrictions on legal rights, or other disadvantages. If there's a lack of transparency, so lack of transparency in the presentation of contract terms may contribute to the unfairness of a term. Consumers should be able to easily understand and digest the terms that they are agreeing to. Unfair contract terms are much more likely to be scrutinised in standard form contracts where one party has drafted the terms and the other party has little or no ability to negotiate. So some examples of terms that may be considered unfair include terms that allow one party but not the other to avoid or limit their obligations under the contract, terms that permit one party but not the other to terminate the contract, terms that penalize one party but not the other for a breach or termination of the contract. So these unfair contract term provisions apply to standard form consumer contracts, standard form small trade contracts. So this is where at least one of the parties is a small business and the contract value does not exceed 250,000 New Zealand dollars annually. And certain contracts and terms are exempt, such as terms that define the main subject matter of the contract or set the upfront price payable, but this is dependent contract to contract. So what should you do if you receive a contract that contains these terms? If you receive a contract that you think contains unfair contract terms, you should first assess the impact that it may have on your business if included in the agreement. What's the detriment by having that term in there? If the unfair contract term is likely to have a negative effect on your business, it's best to negotiate the removal of this clause from the agreement. Now, it's important to note only the Commerce Commission can ask a court to declare a term unfair in standard form consumer contracts. However, both the Commerce Commission and parties to small trade contracts can apply to the court for a declaration that a term is unfair. So that's in small trade contracts, not in the consumer contracts.
Thanks, Georgia. Sometimes, despite your best efforts to make a contract more favourable, the other side will be unwilling to make any changes. If this is the case, insurance can provide a valuable safeguard for protecting your business. You should speak with your broker to ensure that your insurance covers the risks you might be facing in the agreement. This proactive step ensures that your insurance aligns with the contractual terms. This is particularly important if the contract in question is high value or high risk. Your broker may also be able to tailor your insurance policy to cover your business against the intricacies of the contract. So turning to the poll question that we asked at the beginning of the webinar, it looks like most of you, so 73%, your main focus when reviewing a commercial contract is identifying hidden risks like indemnities and liability exclusions. So hopefully our webinar today has provided you with some guidance on that. So that concludes the main part of our webinar. You might find our publication useful. Download our commercial contracts checklist in the resources tab or by scanning the QR code. You may also be interested in our upcoming event, which is Buying a Business, How to Undertake Due Diligence, and it's on Wednesday, the 9th of April, at the same time as this one. So next, we're going to answer your questions, and while you submit them, we'll take a minute to tell you about LegalVision's membership. By becoming a LegalVision member, your business gets unlimited access to our full team of 100+ specialist lawyers for all of your business as usual legal needs. It's like having your own in-house counsel for a fraction of the cost. Our team can assist you with unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, unlimited trademark registration domestically, and much, much more. As a LegalVision member, you won't worry about the cost of lawyers ever again. Think of it as having your own in-house counsel. We'll take care of all the business as usual legal work so you can focus on running your business. And if you are in-house counsel, we also offer a dedicated service to manage your high volume business as usual legal tasks. To learn more about how membership or desk extension can help you, please request a free consultation when the survey appears at the end of this webinar. And now we will answer some of your questions.
So one of the questions that we had come through is what liabilities cannot be excluded from a contract. So unfortunately, you can't exclude every single liability. There are certain liabilities that cannot be excluded or limited at all. So some of these that generally cannot be excluded or limited would be your obligations under the Consumer Guarantees Act. So that's for consumer transactions. Businesses cannot contract out of their obligations. This includes guarantees of acceptance, quality, fitness for purpose. You also can't limit your liability or exclude liability for fraud or intentional misconduct, for a fundamental breach of contract. Some other areas that cannot be limited or excluded would be rights under the Employment Relations Act or the Health and Safety at Work Act. So while there are some liabilities that you can exclude from a contract, not all of them can be excluded. So we do recommend talking to someone about that. One more, sorry.
I'll
Jump
take
in.
this one.
Yeah.
So another one that's come through is what is a standard form contract? So that's referring to the unfair contract terms points that Georgia was talking about above. A standard form contract, also known as a boilerplate contract or take it or leave it contract, is a pre-prepared agreement where most or all of the terms are set in advance by one party, usually the business offering the goods or services. They're usually used in transactions where one party engages a business to provide certain goods or services, and they are standard form because they're generally not negotiable. So live questions that have come through, we've got I've seen a franchise agreement contract that includes a loss of revenue clause, i.e. the monthly fee has to be paid to the franchisor regardless of whether revenue is made, and including if the business is closed. Could this be considered an unfair contract term? So franchise agreements, whilst obviously being commercial contracts and covered by an unfair contracts term, the unfair contract term regime, provided they meet the criteria, particularly around value, are relevant here, but there's also something broader to be considered with franchise arrangements. So yes, potentially it could be considered an unfair contract term, but you would need a lawyer to go through a balancing exercise, looking at all those points that Georgia discussed regarding fairness and the wording within the Fair Trading Act as to whether something is considered an unfair contract term. We can't say straight off the bat if it would be considered an unfair contract term or not. Okay, well, if there are no more questions, that's all we've got time for today. Please submit your details in the survey at the end for assistance with any questions that you have that we haven't answered, and to learn more about how our membership can help you. And while this is a free webinar, we do value your feedback. So please complete the 30-second survey at the end. Thank you for joining us.
Thank you.